That one's live. And now do the next one where you copy it from Instagram.
Perfect. So let's go on Instagram. Let's create live.
Yeah. Okay. So we are live on YouTube, and in just a moment we will be live on Instagram, and we will start the Tax Files podcast. It's coming. Welcome to the live. Whether you're in YouTube or Instagram, you'll be watching this in a moment. We will get started. Today we're going to read a case I've never read, and I'm pretty sure Raphael has not read either.
I have not read
I've
it.
not read this Gladden Estates. So we're gonna learn where something comes from that we have read, the quote that we have read. So do you think we're
I think
good
we
to
are
go?
live now. I think
Okay,
we
great.
are. Are we?
I'll be able to tell you in just a moment. Yes, it looks like yes. Good to go. All right. So over to you.
Hi everyone and welcome to the Tax Files.
Oh. It was about to be creepy there for a second.
Hi Prof. Christians,
Hi.
welcome to the Tax Files.
Oh, it's great to be back to the tax files. You know I love a good tax file.
It's great. First time on a Sunday. And
That's true.
First time on a day where the weather is literally from
Yeah.
the X-Files.
Yeah, it's pretty creepy out there, I will say. Yeah.
But I would not be surprised if I see an alien today.
Well, aren't there aliens? Aren't all those files being released, and we're allowed to see that there were all these alien sightings? This is a real
Yeah.
thing now.
Yeah. And apparently there's like many different types of aliens.
Okay.
And yeah, I'm not up to date in the alien world.
I don't know. But all right. So, yeah, let's get it going on. What are we on? We're on
Okay, so
a
as you
famous
see on
quote. A famous
screen,
quote.
We are reading an old federal court trial division case, the estate of the late John N. Gladden. And you will ask me, why are we reading this? Who cares about this?
Right.
Well, the reason why,
It is.
and I'm going to put some music to describe this. If you read Crown Forest, you read Alter Energy, you will see a quote, the quote from Gladden,
Right.
about the true intention of the parties.
Okay.
The exact quote is that statutes are different than treaties, and treaties must be interpreted with a view to implemented the true intention of the parties.
That's right. The true intention. Yeah.
And people think this is from Crown Forest.
I
But
thought that was from.
It is
yeah.
not Crown Forest. It
Okay.
is the Supreme Court of Canada quoting a federal court case and saying the federal court said this, and we agree.
So we approve.
We prove, yeah.
Okay.
And so I will read from Alter Energy, the words of Justice Cote.
Okay.
And she says, however, unlike statutes, treaties must be interpreted with a view to implement the true intentions of the parties. J. N. Gladden Estate versus the Queen, 1985, Canley 6138, at page 166, quoted approvingly in Crown Forest at para 43.
Okay.
So we all think this is the quote from Crown Forest,
Yeah.
but it's technically not. It's
Yeah.
from this much older case from 1985.
1985. Great year. Great year.
And so this is why we're reading Gladden.
Okay. Okay. I'm very glad that we're reading Gladden, the estate of the late John, to be.
Yeah, so
be
the
clear.
estate of the late John N. Gladden.
Yeah.
Do you think N stands for something, or it's like,
It's funny. There's no period after
no,
it.
it's just N?
Yeah.
Like, isn't your birth certificate like your name is
Yeah.
N?
Like Nathan or Nicholas.
or just N?
Just N.
So the plaintiff That's the first time I see this word for
A state of the
tax case.
Yeah, it for a plaintiff.
Usually would be
Appellant.
the appellant and
Yeah.
the respondent.
Yeah.
And we have the plaintiff and the
Okay.
defendant.
Okay, so we're already a little not sure what's going
Yeah.
on here. Okay.
And
good.
Her Majesty the Queen
Okay, of course.
in person.
Yeah. Not on camera, but yes.
So we are talking about the Queen here, of course. She's the defendant and not the respondent for some reason.
Okay.
And
so
this
it
is-
says, but it is funny language. So maybe this is just like an old way of doing things, because it does
Yeah,
say.
probably. It's old. It's like Federal Court Trial Division. Ooh,
Yeah.
I'm
But
very
it's but
fast.
it says on appeal from a decision of the tax court
Yeah.
of Canada.
So,
So-
January 22nd, 1985, an appeal from a decision of the tax court.
Okay.
And John Saunders for the plaintiff and John Kennedy
Lots of
for the
Johns.
defendant.
Okay.
So
Two
it's
John.
John
John P.
Gladden,
John.
John Saunders, John Kennedy.
Yeah. Good.
It's Justice Addy. I'm not sure if it's John.
If so, I'm gonna get annoyed. There's too many. Okay.
So, first sentence of the case.
No, but J there means justice.
I know
not
it's
John.
justice.
Okay. Okay.
But we never know. Could be John.
That's.
If
okay.
you know, drop a comment down below, like and subscribe.
Is it John? Is it Justice John Addy? I'm just gonna Google it. Let me just find out while you read. I'll find out and then I'll let you know.
So Justice
Okay.
Addy says there is no dispute as to the facts in this case.
Okay.
This is good. Like when you don't dispute the facts, it's only a question of law.
Right. This is a legal dispute.
Yeah.
Okay.
The deceased, an American citizen and resident, died there during the 1977 taxation year. At
Okay.
the time of his death, he owned shares in 2 privately controlled Canadian companies. So, he owned shares. Okay, so we have 2 Cancos,
Yep.
resident in Canada and
Yep.
owned, controlled by Canadians, and he owns shares in those 2 Cancos.
Yeah, but it doesn't say Canadian control. It just says 2 privately controlled.
Privately controlled Canadian companies. But they are Canadian, so they are resident in Canada.
Yeah. Right.
Well, under the ITA, maybe not under the treaty, but we don't know. It's the first time I read the case, by the way. I don't know the facts. I know Crown Forest, but I
Right.
don't know Gladden.
We're about to find out.
And every time I quote this, it's like, it's Crown Forest quoting Gladden. It's like what Gladden is about.
Yeah.
I don't know.
Yeah.
And now we will know.
Well, I did look him up, and it's George.
George.
George Addy.
Oh,
Yes. Thank you very much. Yes.
that's very, very, very sad.
That's too bad. We could have had a John and a John and a John and all the John. Okay.
Would've
But
been
it's
fun.
George. Anyway. Okay.
So a capital gain
Sorry.
of 75,387.50 was reported at the time of death on the basis of a deemed disposition of the shares pursuant to paragraph 75A of the Income Tax Act.
Okay.
Okay, that's fine. When you die, the first thing you do is paying taxes. You dispose of everything at fair market value, so
Yep.
capital gain.
Yeah.
The estate claimed exemption from taxation pursuant to Article 8 of the Canada-US Tax Convention.
Okay.
The minister maintained the assessment, claiming the tax was payable thereon and that the provisions of the treaty were not applicable to the present case.
Okay. Are we going to get the treaty and the like? Are they going to tell us what language later? Maybe. Or are they going to think? Oh, maybe. I think I see it below, so I should be
Are we?
patient.
Oh,
I
yeah.
shall be patient.
Okay, you shall
Okay.
be patient.
I
Sorry.
shall be patient.
It's coming.
It's just hang on. It's always coming. So
But
like
If
relax.
you tell me like this is the provision that applies,
Yeah.
I want to read
immediately,
it now.
immediately,
I'm
right?
like, what is this?
Yes.
I don't know what 8 of the treaty is.
Exactly. I'm like in my mind, like, well, it's not business profits. So what's right after business profits and before?
Is it the capital gain provision?
But I don't think so. I think that's later. But this is the 1985
But
treaty.
It should still follow the OECD model. I don't know if you have the
I think I
model.
could look it up, but it's about to be there. So keep reading. Yeah, oh, look at that! It's the 1942 treaty.
Okay, but now I have a very short attention span.
I know,
if
but
you
it's
tell
coming.
me a provision, I'm just thinking, what is 8?
I'm just saying it's coming. It's like it's next. I can see it.
Okay.
It's 1942. It's the 1942 treaty. Like we're really going in the way back machine now.
It's a time travel
Yeah,
experience.
it totally
Especially because we are at the beginning of this idea of the true intentions of the parties.
Yeah.
You think it's ground for us, but it's not. This is really the beginning of this idea.
Exactly.
And I'm really hoping they will tell us what is the false intentions of the parties.
That is my hope as well. But I guess we'll find out. Oh man, all these acts that have 2 volumes, I can never find what I'm looking for anymore. Okay, I've got it.
Yeah, like the definitions.
But this is not going to have the right treaty in it because this will be the current treaty and not the old one, right?
Yeah.
So it's not going to help me. I don't know why I bothered doing this. I should just look it up online. Okay. Anyway.
It will be the treaty with the 5th protocol anyway, so it's like years away. But in terms of...
No, because it's the 4D2 treaty.
Yeah, but now we have...
Yeah.
Is it the 95 and the 5th protocol of the 95? So it's probably very different.
Okay.
But I'm expecting the nomenclature to be the same. Like
I assume.
the article, like 12, is always the same.
I don't think so. So I can look up the old one and find it for you. Here it is. Okay, Article 1. Oh, this is a protocol, maybe?
It's probably a protocol.
Okay.
Let's keep reading.
Okay, let's keep reading. And then if they don't give it to us, then we'll look it up.
Okay. An appeal against the assessment was brought before the tax appeal court. The tax appeal court? That's not the tax court? Was there a tax appeal court before the tax court?
Was it the board of tax? But it said that this case was
from
appealed from the tax court of Canada.
I know before the tax court was like the appeal board.
See it, the tab. Yeah, tax appeal board.
Yeah. So maybe it's actually the tax appeal court. On the basis the deceased had been married to Mary A. Gladden.
Okay, we now find out they just don't use a period after the middle name, initial.
Or maybe her name was just A. It's a possibility.
Strange coincidence. But yeah,
I think I should just use their second name as their first name. So I'm A. Gladden and N. Gladden.
It's better than B. It could be Gladden. And then people would tell you to just be Gladden all the time. Anyway, sorry. Okay, so sorry. We're a little confused because we've got some weird things happening here where it's an old treaty that we are not familiar with the numbering, so we don't even know what provision you're at. Then we thought we were on appeal from the Tax Court of Canada, and now we're saying that an appeal was... is it the old style where you first went to the Tax Appeal Board and then up to the case of first instance? And would that
No, it was appeal board and then the federal court trial division. So maybe that's the case, because we are at federal court trial division.
But then why does it say Tax Court of Canada?
Maybe that's the mistake.
Okay. Well, this is very confusing. Womp womp. Yes, exactly. Yeah. Okay.
So they were married under the community of property regime of that state.
Okay.
The tax appeal court held that the capital gain was taxable only on 1/2 of the value of the shares, since the wife was fully entitled to her 1/2 interest.
Okay.
This part of the decision is now undisputed.
Okay. Meaning what? That she was involved? She was entitled to her half?
Yeah, she was entitled to her half.
Okay.
The issue before me involves the question of whether the capital gain on 1/2 of the total value of the shares is taxable or exempt.
Okay, the issue before me involves the question of whether the capital gain on 1/2 of the total... Okay, so they've agreed that the wife... so when the guy dies... half of the capital gains belong to her. She's still alive, so those are not disposed of. Only the half that are attributable to him. And then now you get your article. Okay, good.
Article 8 of the 1942.
It is the capital gain. There you go.
Canada-United States Convention and Protocol, which was the formal name of the treaty, reads as follows.
Okay.
Article 8. Gains derived in one of the contracting states from the sale or exchange of capital assets by a resident or a corporation or other entity of the other contracting state shall be exempt from taxation in the former state, provided such resident or corporation or other entity has no permanent establishment in the former state. Oh, that's it.
Okay. So gains derived. Okay, so let's just parse this out. So we have a U.S. Citizen and resident, and they are deemed to have disposed of their shares in a privately controlled Canadian corporation. Yeah. So gains derived in Canada
from the sale
or exchange of capital assets by a resident of the U.S. shall be exempt from tax in Canada.
In Canada, yeah.
Provided the resident or corporation has no PE in Canada. All right, so it was a full capital gains exemption this is the U.S.
That's
wow.
a good one.
Full capital gains exemption for residents in the U.S. so long as you didn't have a PE in Canada.
And what's the argument? Is Mr. Gladden a PE? Is he an
saying,
agent?
Yeah, what's the government's
Yeah.
argument here? That's a good question. Maybe they're going to say that he has got a PE.
Yeah, maybe he's the agent or something like that.
Maybe so. Okay,
let's keep reading. Paragraph 75A of the Income Tax Act provides as follows. 75, depreciable and other capital property of deceased taxpayer. Where, in the taxation year, a taxpayer has died, the following rules apply. The taxpayer shall be deemed to have disposed immediately before his death of each property owned by him at that time that was a capital property of the taxpayer other than depreciable property or prescribed class, and to have received proceeds of disposition therefore equal to the fair market value of the property at that time.
You are coming in and out for me. Are you coming in and out for you?
A little bit.
Yeah.
I think I was just too far.
Okay.
Because now I'm kind of reading this
Yeah.
on the screen. It's like
we're gonna fix this the next time. I think you need the screen to be here.
Or just maybe I should hold it like that. Maybe it's better because it's a bit higher. Well, you know what? We should just print the cases.
I think that we should just print the case for you because this is nonsense. You having to hold your screen is nonsense. So next time we'll print. That or we could stop and start over. Shall we stop and start over?
No, let's go.
Okay.
Let's
keep going.
I'm feeling like I will take your order.
We have a lovely bread on the menu tonight.
Miss, can I take your order? So tonight's special is
beans provençal avec. Okay.
So we have a beautiful steak tonight.
Take my order. Take my order.
And so this restaurant is fully deductible, of course. We will give you a receipt saying it's a business expense.
There you go.
Yeah.
Okay.
Well, it's half, So what we could do is just providing like 2 receipts.
Yeah.
It's still half.
It's still half.
But one is just a notional amount that you will not pay. So now it's fully deductible, Welcome to our restaurant.
In any event, this is the best restaurant in the world.
Yeah.
Yeah.
I will call this the fully depreciable restaurant.
The fully depreciable restaurant.
But was it a restaurant of Uber that they were labeling their stuff as like business expenses? Like you order a cheeseburger and it says like a stapler.
That's right.
And people were trying to like fully deduct.
Yes. What was that? Was that a case? That was, we need to look that up.
Yeah, I think we need to also to send the CRA an email at CBIS2.
We need to print that email out because I already forget all the letters in that. And we need to print that out and put that like in a prominent place so we can note that whenever it's necessary to.
Well, I think on the podcast it should be on top of the screen.
Yes. At all times. Cigar, Sagar. Yes. Okay. Anyway.
Okay, let's keep going.
Okay.
The plaintiff argues that the intention of the parties was obviously to exempt non-residents of each country from capital gains tax, which that country might impose.
Right.
Canada, in fact, did not have a capital gains tax at the time, but the wording of Article 8 is quite clear. I therefore fail to understand the finding of the tax court below. Oh, it's the tax court now. To the effect that because Canada had no capital gains tax, it was not and is not bound by Article 8. What?
Okay, I'm fully confused right now. Who is trying to impose a tax if not Canada?
So Canada tried to impose a tax, and I think the
Without
tax court...
Yeah, they didn't have a capital gains tax when the treaty was signed, so they're saying we adopted the capital gains tax afterwards, and so the treaty doesn't apply?
It seems to be the argument. It's like we cannot have contemplated the fact that we would exempt Canadians or non-residents from the capital gains tax because it did not exist when we signed the treaty.
Therefore, we could have had no purpose,
no intention,
no intention
of not taxing you.
Okay. And here, the federal court,
It
Justice
seems like
Addy says, what are you talking
weird
about?
treaty override.
Yeah. Just
Okay.
fails to understand the finding. But the tax court agreed
The tax court agreed
with the government.
Yeah.
Okay. Okay.
Okay,
Strange.
after quoting the article textually, the learned judge summarily rejected the argument with which I am dealing in the following terms.
Okay.
The parties could not have negotiated to avoid double taxation on a tax which did not exist in Canada.
Okay. Interesting.
But when you sign a treaty, it's a bit like it applies equally to both sides. So the U.S. is like saying, if ever you implement a capital gains tax, we don't want our residents to be taxed.
It's hard to imagine a reciprocal provision to be later interpreted to have only been one side thought.
Like, who would sign the treaty saying, you will not tax my residents,
Right.
but I will tax yours?
Right.
Doesn't make
Well,
sense.
I mean, that we do see that sometimes, but you're more clear when you're
Yeah.
going to do that. Yeah.
But it's like,
In a
I don't see
reciprocal-
how the intention could be that
Right.
if it's not clearly
In a reciprocally
non-reciprocal.
worded provision where you have to fill in the parties and which side, and like it goes, and like we just did.
Why would you sign the contracting state in the other contracting state if it only applies
Right.
one way?
Right. Well, he says right away.
Yeah. So it seems to be trite law that a person can contract in anticipation of the possible occurrence of a future event.
Okay.
Yeah, okay.
Yeah.
It is important to note in reading Article 8 that neither country reserved the right to tax a gain arising out of a deemed disposition. There are no exceptions, exclusions, limitations, or provisos in the article or anywhere else in the treaty which might affect restrictively its application.
Right.
And I agree with that. That's good.
Yeah. So far, so good.
The treaty was adopted, approved, and made part of domestic laws of Canada by the Canada-United States of America Conventions Act, 1943, 7 George VI, Chapter 21st.
Whoa.
You know,
what-
it's so old that it's
wow.
George.
7 George the Sixth, meaning, what does that mean?
It means it's Chapter 21 of the laws passed in the seventh year of the reign of George VI.
Oh, okay.
Yeah, that's when when you have those very old laws.
Right.
Right now it's like Laws of Canada
Yeah.
2026, Chapter 6.
Yeah.
But back then it was quoted in terms of the year of the king.
reign of the king.
Yeah.
Nice. Okay.
So it's
Good
the
to know.
laws from the seventh year of the reign
Okay.
of George VI.
Okay. Okay.
Yeah.
Okay.
I just love those very old way of everything is related to the king.
To the king, I know, to the royal family. Yeah. It's true.
It's like we are a year. This is the seventh year of the king.
Yeah. Great. Congratulations.
It is obvious
Yes.
that since a
obvious.
treaty is a contract, Canada cannot unilaterally amend tax legislation contrary to the treaty, except by amending that particular statute which adopted the treaty.
Right.
Furthermore, this general principle of law is emphasized and spelled out statutorily in Section 3 of that Act, which specifically provides that, should there be an inconsistency between any part of the treaty and the operation of any other law of Canada, the former shall prevail.
Okay.
The case of the Queen versus Melfort Developments is very much in point.
I've read this one, but I don't remember much about it.
Okay, so Melfort Development says it doesn't apply anymore because the OECD changed the treaties, the model treaties, and the commentaries after Melfort. But
Okay.
it says, it was a question, I think it was a Canada, Germany or Canada, Denmark. I think it's Germany, I'm not sure.
Okay.
It was a treaty. And the question was, it was an old treaty signed in maybe the 60s, 50s, which relates to the word interest.
Okay.
And so the question was, do we want to interpret the word interest in the treaty at the time we are doing the interpretation at the time of the facts,
Okay.
or at the time the treaty was signed.
Okay. So it was asking
yeah.
for whether we had an ambulatory interpretation or not.
Exactly. So are we stuck with whatever interest was in the IT in the 50s,
Right.
or can we say it's interest in the 70s?
Yeah.
And the Supreme Court said you're stuck with the interpretation at the time the treaty was signed.
Oh, that is contrary to the OECD's view of the world.
Exactly. And so the problem is, so every time you make a change in the ITA, you would need to sign a protocol or a new treaty.
Right.
And what would be this new treaty except the exact same treaty, but now the word interest means
What it means in
what it means now.
Yeah.
And the
What a
OECD
mess.
changed the model after Melfort to say the interpretation of a term not defined in the treaty means what that term means in domestic law at the time of the fact.
Yeah.
Well,
Yeah.
it's like at the time.
When you're implementing it.
Yeah.
Yeah. Yeah, exactly.
And the communities were changed. And even there's a tax treaty interpretations act in Canada
yeah.
that also says
Yes,
this, that it's
for sure.
ambulatory
Yeah.
interpretation.
Yeah, exactly.
And
yeah.
so it's a good example where a decision of the Supreme Court went back to the OECD. You know, this idea of the recursive cycle.
Yeah.
It's really like, okay, we have a Supreme Court of Canada saying this thing.
Yeah.
And all the countries of the OECD were like, that's not what we want the treaties to be interpreted like. And, you know, if the Supreme Court of Canada says something, if you go to the Supreme Court of any other country, they're going to be like, yo, Canada said that, and it's the Supreme Court. They must know what they're talking about. So we have a precedent that is quite important.
Yeah.
And, you know, if you're the Supreme Court of France or whatever, it's a bit hard to say, yo, Canada is wrong. The Supreme Court of Canada is wrong.
What do you think in Supreme Court of Canada? Right.
We
They don't wanna do
think
that.
we want another interpretation.
Yeah.
And now it's like, okay, so you would interpret the same treaty. In my example of Canada, France, Canada would mean something, France would mean something else.
Yeah.
Doesn't really make sense.
Based on when it was enacted versus when it's being implemented.
Especially if
It's
the
a mess.
court
It's
doesn't
a
agree.
difficult problem, actually. Yeah.
And the only solution was going back to the OECD and changing the model. And it's like the question, when the OECD changes the commentaries, can you apply those commentaries before they were signed?
Right.
Retroactive application.
Yeah,
of
we're
the
still having,
commentaries?
we're still having that discussion. Yeah.
In Alta Justice Cote is basically like, you know, if it confirms a view that the countries had before, that's fine. You can use them. But if it's something new, you cannot use them.
Yeah. Treaty Interpretation 101.
Yeah.
Yeah.
Pacta sunt servanda.
Yes, pacta sunt servanda, exactly.
The true intentions, just intentions.
True, whenever you add true to anything, it makes it more serious.
I'm really hoping that this decision says you don't follow the false intentions of the parties.
Yeah.
And these are the false intentions.
Who's got some false intentions? We need to, yeah, root them out.
Okay, so that's Melfort developments.
Okay.
So both divisions of the federal court, as well as the Supreme Court of Canada, held in favor of the taxpayers who were originally assessed on the basis that they had failed to pay non-residents withholding tax on guarantee fees paid to a German bank. Oh, it's a German bank.
Okay.
Then, in turn, argued that they were exempt since industrial or commercial profits were exempted under the provisions of the Canada-Germany Tax Convention of 1956. Oh, it's the 50s. I was also right for this.
Okay.
And on the grounds that the guarantee fees had to be classified as such. The minister argued that, pursuant to a 1974 enactment, which provided that guarantee fees would be deemed to be interest, a non-resident withholding tax was payable. Section 3 of the Act adopting the Canada-German Treaty is identical to Section 3, which I have quoted, supra, of the legislation adopting the Canada-US Treaty.
Okay.
Justice... What is this? What is this name?
Yuri.
Yuri? Justice Yuri?
Yeah. Yuri.
Yuri.
Yeah.
Well, like, maybe it's French. It's like Urier?
Peut-être, but wouldn't you have an accent aigu on the E?
Yeah, that's why I was confused.
Ben, Uri, est-ce que
Uri?
c'est possible?
It sounds
Uri?
weird. I've never heard that.
Non.
Yuri?
On commence un nom avec un U, je pense que non. En français, non.
I've never seen that.
No, I think it's more like
Yuri.
Yuri. It's not
Yuri.
very. It's not. Not common in English either. But yeah,
It sounds a bit like Erie, like the lake.
yeah.
Yuri.
Erie.
Erie.
No,
Maybe-
it's totally different.
Okay, so that judge.
Yeah,
the-
Yuri. Yeah.
So Justice Yuri, if you are listening now, I apologize.
I don't.
And if
I
you know
don't-
how to say this name, please drop a comment down below, like and subscribe.
I sorted out that Justice Yuri is listening. But anyway,
We never know.
never know.
Of the Federal Court of Appeal had this to say regarding the inviolability of a tax treaty.
Yeah. Okay. Yeah. Wow. Like it can't be wrong or it can't be violated.
It can be
Is what
violated.
he's suggesting. Yeah.
Refer page 34 of the report.
Okay.
The paragraph, i.e. paragraph 5 of Article 3, which allowed Canada to tax interest, does not enable Canada to declare that a kind of income that was accorded exemption in the Convention as such profits and is not specifically provided for in the articles that follow shall be taxable. Such a unilateral action would not be possible, in my view, because it would be in violation of the terms of a binding agreement freely entered into by sovereign states. Such
Okay.
an agreement can only be varied or amended by agreement of the parties, not by the action of one party in changing its tax laws by the enactment of its section, such as Section 214.15 in 1974, some 18 years after the agreement was entered into.
Okay. So what is good Mr. Justice, the Honorable Justice Yuri saying? He said,
You signed a
You
deal
can't-
in
yeah.
56.
Yeah.
That's the deal. You cannot change the deal.
but that doesn't solve my problem of what did I agree to in the deal. Like that doesn't, it's not an answer to me. Like if I'm trying to interpret what the meaning of a word is, I'm not saying I'm not going to carry it out. I'm asking, what does it mean?
Yeah.
Right?
You're not changing the treaty unilaterally. You're changing
You're saying
the
what,
word interest. And we all know.
or you're asking what the interpretation
Yeah.
of the word interest is, right?
And I'm pretty sure in the commentaries it was already the case that if a term is not defined, it means whatever it means.
Yes,
in
always.
the legislation.
Yeah, always. Yeah, exactly.
So
Okay.
So what is the argument? It's like, oh, capital gains had no meaning at the time of the treaty was signed, so it has
There's
no
no
meaning.
such thing as capital gain in the
doesn't
Canadian
exist.
income tax system, right? That I think that seems like that's what the argument is. Is that
Yeah.
possible?
It seems weird.
Yeah. Okay.
On the same subject, Justice Estate in the Supreme Court of Canada remarked, see page whatever, laws enacted by Canada to redefine taxation procedures and mechanisms with reference to income not subjected to taxation by the agreement are not, in my view, incorporated in the expression laws in force in Canada as employed by the agreement. To read this section otherwise would be to feed the argument of the appellant, which in my view is without foundation in law.
Okay.
That sub 2 authorizes Canada or Germany to unilaterally amend the tax treaty from time to time as their domestic needs may dictate. It is well to remind ourselves in analyzing these statutes and
Subtended. Now that's an interesting word. I don't actually. This is not a word with which I am familiar. Subtended.
Subtended. I'm trying to translate in French to find the meaning of it.
In analyzing these statutes and the subtended,
Like sous-tendu.
sous-tendu,
Like les lois qui sont
supported?
sous-tendues in subtended. Okay, now I will do a little good.
well,
Subtended.
that is an interesting word.
Subtend is a geometric verb that means to extend under, lie opposite to, or enclose something. More commonly, it describes the relationship between a line segment and an angle.
What?
What?
A line segment and an angle.
Okay, let's
Oh, like if you have an angle, then the line segment is like under it or connected to it or part of. So,
Okay.
like if you draw in your head an angle like
Uh-huh.
this, then this line segment, this is the angle, right? So if this is if this is the angle, this segment is subtended to the angle. It's not the angle. It's not part of the
subtended.
angle,
It's
but it's
sous-tendu.
Yeah.
So it says actually in French, it's sous-tendu.
Sous-tendu.
So it's like, it's ça sous-tend.
Like sous, like under?
It's like, you're not talking about
Or
the,
like
the
supported.
law. It's
Right.
like, on
You're talking about
sous-tend que
something-
c'est ça que on
Yes,
dit.
c'est ça. So it's saying like connected to or in some way.
Connected to.
Huh.
Yeah.
Okay. Learn something new every day, my friends.
Subtended.
Yeah. Exactly.
You know, I really enjoy when I'm like, subtend, what is this? And if you're like, I've never seen this word, I'm like, oh, phew.
Yeah. That's great.
Subtended. Okay.
Subtended.
Tax agreement that the international agreement does not itself levy taxes, but simply authorizes the contracting parties within the term of the agreement to do so.
Uh-huh.
Okay, this is something I think is important. A tax treaty never creates a tax.
That's correct. It,
It
only
only-
relieves.
Yeah, changes.
Sometimes it can affirm,
Yeah.
like it can say, and Canada gets to tax this income. Well, whoop-de-doo, I kind of already knew that. So it can affirm that Canada taxes something, or it can reduce Canadian tax, but it can't increase.
Yeah.
It can't
Like the
increase.
charging provision is never the tax treaty.
Yeah.
And the best
right.
example is interest. You will find in any treaty a rate for interest, 5, 10,
That's right.
15%, whatever.
Yeah.
But in the law, in the ITA, interest is only taxable under Part 13
Right.
if
Yeah.
if it's non-arm's length parties.
Right.
So if you pay interest to a bank, for example, a foreign bank,
Yeah.
it will never be taxable,
That's right.
even if the treaty says it's 5%.
Yeah. So if the statute says 0, it's 0. Doggone it. No matter what
Exactly.
the treaty. And actually, we see this a lot. I've seen this a lot, right? Like I've seen a lot of treaties that provide a positive rate for interest, and there's no positive rate under domestic law. And I've even seen treaties that provided a rate for something that was not subject to tax, that like was not covered in the law. And I remember looking at this many years ago and learning, well, sometimes treaty negotiators just don't care. Like, that's fine. We don't tax it, so put it in there. That's fine. And sometimes they're saying, well, maybe if it's in the treaty, we could make room. We're making room for ourselves to tax it later. So, you know, we don't tax it now, but maybe we will. And if we do, then we won't do it above what we agreed.
Yeah, it's better to have it in the treaty and not have a non-reciprocal provision.
Yeah. Yeah.
Just like the U.S. and Canada did
Yeah.
in that case.
Exactly.
And you want to make sure if ever you actually tax capital gains that you will tax foreign residents.
That's right. Right. Okay. Good.
Where was I? Subtended?
Subtended. Yes. Subtended.
Obviously,
Uh-huh.
it follows that Section 3 or any other part of the 1956 statute can be repealed or amended. The question is not that, but whether the collateral legislative action is in connection with the ITA has the effect of amending the 1956 statute.
Okay.
The suggestion that it does have such an effect is startling.
Oh, not striking.
That's striking. Startling.
Startling. Oh. Wow. We have a new,
Startling.
yeah.
Startlingly.
Startling.
Startlingly.
Oh, man. That one's hard to say. Startling.
Startlingly.
That means like when you see it, you're supposed to go,
Like, you see that and you're like,
you should be startled. You're it's like a jump scare.
it's like, I have something more. Oh yeah.
Yeah.
Startlingly.
Yeah. Yeah. You should be shocked. Okay.
Yeah, you read this and you're like,
Wait a second. Just a second. Wait a second. Okay. One more time.
startlingly.
Start. We're gonna use that picture that I just took as the cover to this podcast because it's startling. Okay,
It's
It's
startlingly.
It's startle. Oh my goodness.
Startlingly.
This is hard. This is a hard word.
Startlingly. But I want to use
The more
like
you say
startlingly.
it, I know. The more you say it, the
Startlingly.
harder it is to say.
I think we have to redo it.
Okay.
Startlingly. With the music.
Okay.
Have to
I'm
switch
ready
webcam.
to be startled. Okay.
Startlingly.
Oh my gosh. Okay.
I just want to actually read like a treaty or a factum
And be startled?
and be startled.
Yeah.
And I'm like, startlingly.
Well, you won't because the effect is startling, right? That's what's going on here. Okay,
Yeah.
so he said this is SD, right? Who's speaking?
Yeah, ST.
He's saying the question is whether the collateral legislative action in connection with the ITA has the effect of amending. I'm not even sure what he's saying. The collateral legislative action in connection with the ITA has the effect of amending the statute.
He's saying if you change the meaning of interest in the ITA, you subtendedly change the treaty.
Yeah, but he's saying the 1956 statute of amending this 1956 statute.
Yeah, the 1956 statute is
The treaty?
treaty.
Ah, okay. The implementing statute.
Yeah,
Okay, so the suggestion that it does have such an effect is startling.
it's startling.
It is startling.
It is. think about it. It's like startling.
Yeah. So he goes on to say so his point is you can't tell me that if you change the act that the act itself changes the treaty.
Exactly.
That would be startling. I would be startled if you told me that. Like that we make a legislative change and now the treaty is changed. Unless you think that there's an ambulatory interpretation.
Yeah, exactly. So it's not startling.
It's not startling in that case. Right.
You tell me that, I'm not startled at all.
Right. If you say
there is an ambulatory interpretation,
Yeah.
I'm just like,
yeah. One of those. Ta-da! Or something like that.
and Justice Esty is looking at this situation and he's like,
Inconceivable!
Okay, so he's not. So to be clear, he's not a fan of an ambulatory interpretation. Is
doesn't
what
like
we're
that.
saying. Okay, I'm caught up. I'm caught up to what SD is saying. He's startled by the idea
Yeah.
of ambulatory interpretation.
I'm just
Okay.
hoping he's not startled by this idea in the context of the Constitution. Do you think he is startled?
Why? What would happen if he was?
Person's case.
Oh,
Then we have a problem.
then we don't have a problem. Then I have a problem. I have a problem. You're fine. You're fine.
Yeah, I'm fine. I'm still a person.
You're still a person.
still a person.
Startling. Startlingly, you are still a person.
Yeah.
Okay.
I mean, maybe the writers of the Constitution, if you tell them that, they would be startled.
Maybe so. They probably would.
Probably.
Actually, that's
They
probably
would
right.
be like, what?
What do you mean? What do you mean? What are we talking about?
That's not possible.
Women? People?
Inconceivable.
Conceivable. Okay. So SD goes on. I like how this is italicized. Is this italicized because he italicizes everything? It says emphasis added.
No, it's like instead of doing underline, you just italicize it for
Okay.
some reason.
Okay.
Why? I don't know.
Okay. So the suggestion that it does have an effect is startling.
Okay,
Fine.
I will not agree.
Okay, I don't agree.
There are 26 concluded treaties.
Yeah. 26. How many do we have now? 90?
Almost 100.
Almost 100. 92, 93, something like that.
I think it's 93 minus Russia.
Yeah.
92.
Right.
I think. I'm not sure.
Okay.
Well,
So,
Russia is technically still in force, just suspended.
So, but this was like a long time ago. When is this?
85.
No, because
Oh,
they're
no, it's
citing
ST.
SD in Melford. Is it in Melford?
Is it 81?
81 looks like. Yep.
Not that long ago.
Yeah.
And-
Actually,
and 10 proposed conventions.
you don't think 81 is that long ago?
I don't think it's that long ago.
My friend, that's a long time ago. That's 40 some years ago. That's 45 years ago. 45
nothing.
years. Nothing. Yeah. In the grand scheme of things, it's true. It's
Yeah.
nothing. But it's interesting. We went from 26 concluded and then 10 proposed. So they had 36 in the works.
If the submission of the appellant is correct, these agreements are all put in peril by any legislative action taken by Parliament with reference to the revision of the Income Tax Act.
Yeah.
For this
Okay.
practical reason, one finds it difficult to conclude that Parliament has left its own handiwork of 1956 in such inadvertent jeopardy.
Wow. Okay.
Whew.
Yeah.
ST used big words.
He did. He was
Big
had a little
words.
bit of floral, a little flowery language. Yeah.
This is not to say that before the 1956 Act can be amended its substance, it must be done by Parliament in an act entitled An Act to Amend the Act of 1956. But neither is the converse true. That is that every tax enactment, adopted for whatever purpose, might have the effect of amending one or more bilateral or multilateral tax conventions without any avowed purpose or intention to do so.
So to do.
So to do.
So to do.
So to do. ST also use
Yes, it's very.
mixing the words.
Yes.
Mixing the big words.
It's very. very highbrow. Very highbrow way
Yeah,
of
it's
speaking.
like, oh, you think this 1956 Act would put you in jeopardy if we changed it? This is inconceivable. I think it is startling what you're proposing today. Mr. Counsel for the Crown. This is inconceivable.
Do you mean to so do?
I don't mean to so do, but you mean to so do.
So to do mean? So mean to do? I don't know.
What do you mean to do so to do? Because if we're doing what you're saying to do, it will be startling. If what you mean to do is the mean to do of the treaty.
The point is, he doesn't like treaty override.
No.
This
And he thinks
cannot be.
that an ambulatory interpretation is
isn't
a
treaty override, which I understand. Like, I understand the viewpoint. I do. It's just a difficult. It's difficult to deal with it.
Also, you're thinking like, if you don't have the OECD commentaries to tell you,
yeah.
well, 1981.
They
in
had
Melford,
commentaries,
They
yeah.
had commentaries. They just came out. You have the Vienna Convention as well, so
Yeah.
you know context is part of the interpretation.
Yeah, but it's
Yeah.
still ambulatory is still a difficult. Yeah, conceptually. Okay, so he's telling us he doesn't like it and he doesn't think it was intended and could possibly be intended, and
Okay.
to say otherwise would be startling.
And we're still not done with ST.
No, we're not.
There is
So
no
he
doubt.
continues.
There is no doubt in my view
Yeah.
that the effect of Section 3 is to make the operation of any other law of Parliament, including the Income Tax Act, subject to the terms of the 1956 Act and the incorporated agreement.
Yeah.
The only exception to this result would be where Parliament has expressly set out to amend the 1956 statute. Then, of course, there is no conflict between the 1956 Act and any other law. This interpretation has the necessary result of embodying the agreement by reason of Article 2.2. Subsection
Okay.
2.2? I don't know. Article
I
2,
don't know.
paragraph 2.
Yeah.
As definitions of the words not therein defined, the meaning of those words at the time of the agreement was adopted. Thus, any legislative action taken for whatever reason which results in a change of expansion of a definition, a change of expansion of
I
a
think they must mean
definition,
or expansion. I think
Yeah.
there's a typo there.
a change or expansion of a definition of a term such as interest does not prevail over terms of the 1956 statute because of the necessary meaning of Section 3 thereof.
Okay.
Okay, fine.
And he's got one more sentence, and then we can.
What the position of the appellant amounts to is an assertion that Canada can simply amend the agreement by the device of redefining the term interest.
Okay, so this is what you see in all those old articles about
Yeah.
treaty override. Like, you can't possibly just override the treaty by changing your internal law, and I understand that argument. Like, I agree, that seems right. But
Yeah, but I
what
think
he's, yeah,
what they mean is you amend the treaty itself.
yeah, but so the treaty override discussion almost always involves you have a treaty in place. Now you adopt a statute that conflicts with the term in the treaty, and you have to be clear that you're overriding the treaty. And how? How can you override it? Under the Vienna Convention, you cannot, right? And so there's been all this conflict in the past with the U.S. just can override, and then the U.S. itself changed its rules for when it could or could not override, and blah, blah, blah. And so SD is just expressing what I think is the standard view of the time, which is that you can't override a treaty. But
And
that's not...
I agree with that.
Right?
That you cannot change
Yeah.
the words of the treaty
Sure,
itself.
right. If you
by
say I'm going to
another
tax
act.
by 10%, you can't now adopt a new tax on the same income and tax at 15%. You can't
That's
override.
illegal, except
Yeah.
if you're the U.S.
Unless you're the U.S., right?
And it kind of
It's
makes
controversial.
sense because if you are signing an agreement with the U.S., you know that they will say they can change
Right.
the treaty
Right,
with their own legislation.
right.
So you know
Right.
what you're getting into.
But what is the point here? If you're saying you're interpreting a word, that's not the same thing as adopting. Well, I guess they are saying that. They're saying
Yeah.
you adopted the capital gain. I mean, by analogy to the current facts. I mean, I guess we're going to get there eventually. But the analogy is you didn't have capital gains, so there was no definition of capital gains. Now you've adopted capital gains after the treaty was already in place. How have you? I don't understand the argument. It just doesn't flow for me. So I guess I'm not sure. I'm not sure
think
I fully get it.
There's a difference between doing a treaty override and changing the internal definition of a term referred to in the treaty, knowing that the treaty refers to domestic legislation.
Right,
I think that's it.
right.
That's the difference. That's why it's not
Okay.
treaty override.
Okay. All right. So our judge in this case, which is Addy, is telling us this is what SD says. Don't think about treaty override. That is striking,
Startling.
startling.
Startlingly.
Sorry, it's not striking. It's startling.
Startling.
Yes. Okay.
You know, this guy is like treaty override.
Exactly.
So
Okay.
everyone. So Justice ST is like treaty override.
Exactly. That is correct. Yes.
Do you think this will become a meme?
Sure.
Yeah.
We can make it so. We can make it so. I see that we have a couple of people joined us and we didn't say hi. So sorry about not saying hi to former students and supporters of the Tiny Tax Ban. I'm seeing them having joined, and so we thank everybody who joins us for these tax files.
So thank
Live
you,
or later.
everyone. Don't forget to like, subscribe, comment down below.
Share it with your friends, etc. Blah blah blah. Okay, so
Send
then
money.
he moves on. Send money? No, don't send money. Don't send money. I mean, of course, you can always send, but we're not. Okay. Anyway,
You can send money to the Canadian Center for Tax Policy.
sure, yeah, fine. Anyway, moving on.
Moving on. The same result was arrived at on the same basis in the case of the Queen versus Associate Corporation of North America.
Okay.
I just like the name of this company, Associates Corporation of North America.
Yeah, there's
Like,
wow.
What are you selling?
Nothing.
We don't know.
We don't know anything.
Refer also to Doris Lillian
Gadsden.
Gadsden
Okay.
versus the Minister of National Revenue.
Okay.
The next issue involves the interpretation, which must be given to the words sale or exchange in Article 8 of the treaty.
Okay, I'm sorry. We haven't resolved anything, but we are on to our next issue, which
Yeah.
is to interpret the word sale or exchange in Article 8. I'm not fully understanding
Not
what
sure
we've...
where we are going.
Yeah, I don't think we've resolved any... I don't understand starting a transition in the middle of a paragraph with no analysis. We just cited SD and then didn't tell us what...
It seems to be ST says that, so that's right.
Okay,
Like
So,
if
okay.
ST said it,
then that's the law.
like
So we're just
that's-
reciting what
that's
the law is.
words of the prophet.
Okay, fine. Fine.
These old cases, I'm always feeling like when you cite the Supreme Court, it's like the words of the prophet.
Yeah,
It's like that.
that's it.
That's
that has
it.
been... You've been laid down, and that's where it's at.
Yeah.
Yeah, agreed. Okay.
Contrary to an ordinary taxing statute, a tax treaty or convention must be given a liberal interpretation with a view to implementing the true intentions of the parties. That's the quote.
Oh, there it is.
There it
Yeah,
is.
Yeah. That's it. That's the money quote right there.
Yeah.
Okay.
That's
Hidden
it.
after a non-analysis. Contrary to an ordinary taxing statute, a tax treaty or convention must be given a liberal interpretation with a view to implementing the true intentions of the parties.
And
okay?
why is that? I mean, what is the what says that?
Well, they're going to tell us.
Okay, a literal or legalistic interpretation. What is a legalistic interpretation?
Formal?
Like
Formalistic?
too textual?
Yeah, no, too textual is not the right word. What am I thinking? Like when you over hyper technicalize something, like technically.
Technical?
Yeah, I would call it literal, but they say literal or legalistic, so formalistic. I don't know. Yeah.
Must be avoided when the basic object of the treaty might be defeated or frustrated insofar as the particular item under consideration is concerned.
Okay.
Article 31 of the Vienna Convention on the Laws of Treaties, 1969, to which Canada subscribed, governs the general rule of interpretation to be applied.
Okay.
Paragraph 1 of that article reads as follows. A treaty shall be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms of the treaty, in their context, and in light of its subject and purpose.
Okay.
Where does it says true intentions?
It doesn't say anything about true or intentions, true or otherwise.
Yeah,
Right.
good faith. I mean,
Talks about good
I hope you do the
In their
interpretation in good
yeah,
faith.
sure. But in light of object and purpose, I guess maybe purpose and intention might be the same thing.
Object. Yeah, okay.
Maybe.
I
Okay.
think what 31.1 of the Vienna Convention says is it's a bit like a GAR analysis in the sense
Yeah.
that you have to look at the object of the provision,
Right.
not just the text.
Right. Yeah.
So I guess that's where intention comes from.
Well, I would say intention means
Object.
what did I intend? What was my object? What was my purpose?
Like, what's the tax policy behind it?
Yes. What was my rationale, reason for adopting this or that? Yes.
Okay, let's keep going. The case of the Queen versus another John.
Oh.
But this time it's John Quickshank.
I applaud you for that. I think it's Crookshank.
Quickshank.
Crookshank.
Quickshank.
I don't actually know. You'd have to look it up on Google, but we'll just go with Crookshank.
So John Quickshank
Yes, exactly. Yes.
dealt with a resident of France. Oh, so it's John Quickshank.
Oh,
Ah, voilà. It's
Okay.
a France resident.
Ça,
So
c'est mieux en
it's
français.
Jean Quickshank.
Crookshank. Parfait. Continue.
So Monsieur Quickshank, who was a resident of France, who received a lump sum payment from a Canadian company to commute a pension. The
Community pension, okay.
The Canada-France Treaty provided that pensions were exempt from tax where the person did not reside in the taxing state. The minister argued that the payment was taxable because the ordinary dictionary or lexicon meaning of the word pension does not include a lump sum payment.
Oh,
That argument of the minister was categorically rejected by Gibson of our court, who held that the word pension should, for the purpose of the treaty, be given a wider meaning than its lexicon meaning.
okay.
Refer page 346 of the above mentioned report. See also William Vincent Saunders versus
Okay.
MNR.
Fine.
I just started reading this like it would be a French name, but
Yeah, you were going for Vincent. And they were like, Saunders. That is not French.
no, I was hoping it would be like Quickshank.
Oh, exact. Mais non.
A statement of the law as to the interpretation in these cases is to be found at page 402 of the report. The passage was quoted, the passage from Mr. Quickshank. I have way too much fun just saying English words in French.
But c'est fun.
Was quoted with approval
Yeah.
on two occasions
Okay.
by trial judges of the federal court, namely by Walsh in Canadian Pacific Limited versus the Queen,
Okay.
and by Grant in
In
Melfort
Melfort
Développement
Development. Yeah.
versus the Queen.
Okay, here we go.
So the passage reads as follows.
I like how they have a little parenthetical here.
Parenthetical. Tax conventions liberally interpreted.
I love it.
The accepted principle appears to be that the taxing act must be construed against either the crown or the person sought to be charged with perfect strictness.
There you have it.
So far as the intention of Parliament is discoverable, where a tax convention is involved, however, the situation is different, and a liberal interpretation is usual, in the interest of the comity of nations.
Oh, wow. Okay.
Text conventions are negotiated primarily to remedy a subject's text position by the avoidance of double taxation rather than to make it more burdensome. So
Okay,
here
well,
you
there's a
go.
lot of assumptions in there.
It is not Gladden that said that.
Right. It was
Canadian Pacific? What?
the passage was quoted with approval, so it's from William Vincent Saunders. A statement of the law as to the interpretation is found at 402 of the report. Sorry, I'm backing up. Like, what was this from? Okay, the argument that the minister was categorically rejected by Gibson J. of our court, saying that pension should be given a wider meaning. Refer to page 3 of the above mentioned report. See also. Okay, so it's Gibson of the above mentioned report, meaning Cruikshank, I assume. The case of the Queen v. Cruikshank, that is the origin of this passage, I believe. This is quite convoluted, I will say. Am I right in thinking that this passage that reads as follows is from the Queen v. John Cruikshank?
I honestly have no idea.
Yeah, it's very
where it's
confusing.
from.
Okay, so it says that, okay, so just let's back up a second. Let's just try to figure this out.
The passage was quoted.
Yeah, it says
The case
that
of
the
Cruikshank.
case of the Queen v. John Cruikshank dealt with the Canada-France Treaty.
So it
The
was
minister
rejected by
arguing-
Gibson.
Yeah. Say it again?
It was rejected by Gibson and Cruikshank.
Yeah. So Gibson
It
rejects
was-
the minister's argument in Cruikshank. It says you need to have a wider meaning. And then he says, see also, a statement of law as to interpretation is to be found at page 402 of the report. Which report?
I think it's the tax court decision
In Saunders.
in Gladden.
No, because look at the page number. Page 402. Oh my goodness. What a mess. Okay, what the heck? Okay,
I don't know.
this is what we get. Actually, this is so common, right? This is what you get when you do cite, and you never analyze. It's like, just tell me who said what and then analyze it. Urgh. Okay, so somewhere, a statement of the law as to the interpretation in these cases is to be found at page 402, 526 of the report. The passage was quoted on blah, blah, blah. Okay? In these two cases. The passage reads as follows, and then I don't know where this is from. So it says of the report, and it says page 420 and in 402 and in parens 526. So if you go back up, 526 could refer to Vincent Saunders. Look at that one, DTC 524. So 526 could be in there.
Yeah.
It could not be in Cruikshank because look at that one, 344 and 5226. But could 344, could 402 be in the same case as 344? That's only 60 pages later. Could it be that long?
Possible. I think we have to do research to know where
This
it's
is
from.
terrible.
And we're never going to find it.
I am so upset when I see this stuff because I don't even know what I'm reading, and you've lost me completely. So I'm not happy, Justice Addy. I am not happy with this.
But also, look at that. The accepted principle appears to be that a taxing act must be construed against the crown the person sought to be charged with perfect strictness, so far as the intention of Parliament is discoverable. So it must be against whatever, so far as the intention is discoverable? What does that mean?
Not only are we at a loss as to where this paragraph came from, what context it arose in, we don't even know what it's saying to us. We don't even know what it's
I
saying.
have no idea.
Okay, good, great, terrific, wonderful jurisprudence.
Well, it seems the more you dig in
Oh,
those
the
cases,
worst, I know.
the more you realize that whatever is a principle comes from
Blah, blah,
nothing.
blah. It comes from blah, 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 blah,
Yeah.
blah. Somebody just said it. And then somebody else wrote it down like, yes, it seems to me it must be so.
Well, it's like the
Right.
Duke of Westminster. It's like,
Yes.
why is that a principle?
Yeah.
Well, because Lord Tomlin said so.
Yeah.
Okay, but why do we trust
Why do we care?
this
Yeah.
guy?
Yeah.
Like, well, he's a lord.
And he carried the day on that
It's
day.
the word of the prophet.
Yes. Handed down through the generations. Okay, so we're struggling. We don't know where this thing is from. It might be from I don't know. Anyway, but then there's this act. Okay, actually, this is important, right? Because still, we will see taxpayers say, you should lean towards textualism if the statute is clear, if the intention is clear, if the text is clear, right? We see this language. And the idea is we see the purpose in the text itself.
And it's the idea, if the text is clear, no need for interpretation,
Exactly.
just apply it.
Exactly. Which is a false...
I think it's a mistake.
A false assertion. Yeah, I agree.
I think
that is a
there
mistake.
is no way to know if the text is clear if you don't interpret it.
You must interpret
Just
it, and
knowing
always...
it's clear is an interpretation itself.
That is itself. Okay. And then saying, so far as the intention of Parliament is discoverable, that seems to be saying, can I discover Parliament's intention? Yes, then I must apply a strict interpretation. Well, you just did.
Yeah.
You just said the Parliament is discoverable, so then isn't that itself a conclusion of law?
I kind of find it funny because when you do the interpretation, you try to find the intention of Parliament. So of course it's discoverable. That's the task.
Exactly. Okay. Anyway, that's your job as a judge. You're supposed to discover it.
Yeah. Okay. Refer also to Ezra Shahmoon versus MNR.
Yeah. Well, it doesn't help me because I don't know what my first is to see, so I don't know what I would see also something else. But yeah, you can dig it up. Fine.
The courts of the United States, the other signatory of the tax convention in issue here, have come to the same conclusion as to the method of interpreting treaties of this nature. Referred decision of the U.S. Supreme Court in the case in Ross, the Great Westlife Assurance Company.
Okay.
It's not insurance?
Assurance you can use assurance instead of insurance. That's allowed.
Assurance?
Yeah.
We can use the French word?
Yeah.
Okay,
I don't know why, but you can.
I'm using assurance now.
Yeah, okay, you can. You're allowed. I mean, it's not that common. Like I have a life insurance policy, but assurance is also...
But I do have a life assurance, no insurance. I'm only assured.
What? What are you
I'm
saying
not
to me?
insured, I'm assured.
You can be assured that I don't know what you're saying, so yeah, that's fine.
Okay, U.S. Court of Claims. And why are we talking about this? I don't know.
I don't
It's
actually
like,
know.
by the way, we're looking at the Canada-U.S. treaty, and the U.S. says the same.
Yeah.
Yeah, but we are in Canada. We're using Canadian principles.
Yes, but we want a meeting of the minds, right?
Yeah, okay. But what if you find a country that does not apply this principle?
Then you have a problem, an interpretation problem, because you have to decide which country's interpretation matters.
I don't think you have a problem in Canada, because when you use a treaty in Canada, you interpret the treaty according to Canadian laws.
Usually, okay, I don't know where this comes from, but the rule is that you apply the you apply the interpretation of the country that is applying the treaty in the way that is being contested.
Yes.
So, right, it's one of the treaty partners is doing something, the taxpayer is contesting it. You have to use the law of that country to decide whether the taxpayer is properly contesting it or
Like
not.
a Canadian court will not use the principles of another country for interpreting the treaty. It's going to be Canada.
Yeah.
Okay, so I fully agree with and adopt the statement of David A. Ward.
That's
in his
David A.
paper.
Ward of Davies, Ward, Phillips, and Weinberg, I believe, right?
Really?
I
Oh,
believe so,
yeah.
yeah. I think that's him, yeah. Great Canadian writer and thinker on tax law. Yeah.
So David Award.
It does look it does look like a Ward, but it's A.
It's A.
Ward.
A Ward.
Probably Andrew or something like that. In his paper on the principles to be applied in interpreting tax treaties.
Which is reproduced at
Oh.
page 264 of the 1977 Canadian Tax Journal.
Okay.
The passage.
Okay, finally we know where
question.
it's from at least. So now we know we're reading a secondary source. And this is somebody who's widely recognized as an expert in Canadian
So Mr.
jurisprudence.
Ward
Mr. Ward says,
in interpreting and applying tax treaties,
yeah,
the court have said they should be prepared to extend a liberal and extended construction to avoid an anomaly which a contrary construction would lead to.
yeah,
As the court has recognized that we cannot expect to find the same
nicety
of strict definition as in modern documents, such as deeds or acts of parliament, it has never been the habit of those engaged in diplomacy to use legal accuracy, but rather to adopt more liberal terms. Therefore, the weight of authority would appear to be against the type of strict interpretation of a tax treaty, which would normally be applied to an exempting provision of fiscal legislation. The justification for this general rule of interpretation probably lies in the contractual nature of a tax treaty,
Yeah.
rather than its formal ratification by Parliament as legislation. I agree with
Okay.
that. That's
Yeah,
good.
yeah. I like it.
I like
See?
this.
Yeah. There's a reason that people respected this guy. Mr.
Article-
Award.
Mr. Award?
Award.
Award?
Yes.
David Award.
I would give an award for that.
Yeah. It's good paper.
Yeah.
It's good,
It's good paper.
good paper.
Yeah.
Good paper. Do we have congratulations somewhere?
Do we what?
Do we have like applause?
Yes. Very good.
Mr. Award.
Very good, Mr. David.
If ever you're watching, drop a comment down below, like and subscribe.
Read David Award's papers. Because he's a
And
pro.
Mr. Award, if ever you're listening to this,
Yes.
drop a comment and we will give you an award.
No. Yes. Yes, for sure we will. Okay.
Article 32 of the Vienna Convention, entitled Supplementary Means of Interpretation, provides recourse may be had to supplementary means of interpretation, including the preparatory work of the treaty and the circumstances of its conclusion, in order to confirm the meaning resulting from the application of Article 31, or to determine the meaning when the interpretation according to Article 31a leaves the meaning ambiguous or obscure, or b leads to a result which is manifestly absurd or unreasonable.
Okay.
I would say a result that is startling.
Yeah. Right.
Yeah. It's like you do the interpretation and you arrive at the result and you're like,
This one is getting too much of a workout on this on this episode of the Tax Files.
this is the tax files.
This is the Tax Files.
As to the surrounding circumstances, when the treaty was signed, Canada had no capital gains tax legislation, and the U.S. legislation at the time used the term sale or exchange. Oh, that's why. This
Okay.
accounts for the reason why those very words were used in the treaty. There seems to be little doubt, however, that the general intention was to exempt non-residents of each of the
Each, yeah.
contracting countries
Yeah.
from capital gains taxes generally. With regard to paragraph B of Article 32 of the Vienna Convention, regarding the avoidance of a result which might be manifestly unreasonable or absurd, to hold that a deemed disposition would, as claimed by the minister, be taxable as a capital gain, while a true sale or exchange would not, would be both unreasonable and absurd.
Oh, that's
Real
interesting.
commercial transactions would be taxable.
I don't know why they're saying sick. Real
What?
commercial transactions
Okay.
transactions would be taxable. Sick.
Usually you use sick when you quote someone if there's a mistake.
Yeah.
Because if
What's-
you use
what's the
sick in your
mistake?
own text, just correct the mistake.
Yeah.
So
Yeah. What the heck is
What?
going on here?
would be taxable sick, while artificially created ones would not. What?
Okay, I don't know what's going on there, but okay.
In the case at bar, for instance, it is abundantly clear that had the deceased disposed of the shares immediately before his death, in consideration of payment of the full market value thereof, his estate would not have been taxable in any way on the capital gain. Yet, because he died and there is deemed to be disposition of the shares, the result would be that his estate would be taxable although no real sale or exchange or other disposition of the trade took place. The estate was taxed in the United States on the shares on the basis of an estate tax liability and certain arguments, or addressed to the question of whether taxation on the value of an asset pursuant to an estate tax or succession duty statute in one country can be considered double taxation when the incidence of the tax on the same asset arising out of the same event is based on the capital gain in the other country.
Okay.
There is no need, in my view, to determine this issue at all, since on a simple reading of Article 8, it seems evident that double taxation is neither a condition nor a prerequisite for invoking the protection of the treaty.
That's true. That seems
Of
right.
course.
Yeah. Pretty
Well,
straightforward.
but there could be still be double taxation if ever you double tax. but
Yes.
that's not the criteria.
Right.
I mean, we don't care.
I mean, he mentioned before that the point of the treaty was to prevent double taxation, which you could then use as an interpretation to say, well, there's no double taxation, so why should I care? But now there is, obviously,
There is, yeah.
at this
So
point.
I care.
Right.
Yeah.
Okay. We care.
We care. I care. I care about double taxation. It's a big problem.
Okay.
Where was I?
If Canada or the U.S.
If Canada or the US were to abolish capital gains completely, while the other country did not, a resident of the country which has abolished capital gains would still be exempt from capital gains in the other country. This, in effect, was the situation between the time the treaty took effect and Canada, in fact, first imposed a capital gains tax.
Right.
During that period, Canadians could benefit from Article 8.
So they would get tax-free capital gains from the U.S. even though that's not double tax because there was no tax in Canada.
It's like double non-tax.
Yeah, basically they could get double non-tax, right? Which is, I mean, that's exactly right. Like when you make a reciprocal exemption and then one of the countries doesn't tax, then
you have
there's
double
no-
non-tax, and then
Yeah.
there is BEPS,
Yeah.
and there's a problem.
Right.
and
fix it later.
Yeah.
Fix it later.
It's like fixed
Yeah.
later.
Yeah.
Article 16 provides for procedure for a taxpayer to lodge a claim in his own state for a review of the question by both states, but this need only be invoked by the taxpayer where the convention does not specifically provide for exemption and the taxpayer feels that there is in fact double taxation.
They feel it in their heart.
We feel it. Is there double taxation? We don't care. Do you feel double
How do you
taxation?
feel? Do you feel doubly taxed?
I feel doubly taxed. I feel like
I feel doubly
triply,
taxed every time
quadruply, fifthly. I feel taxed.
Yeah, I feel doubly taxed every time I go to the grocery store and have to pay a sales tax after I already paid tax on my wage income. We're going to fix that? It's startling.
Yeah, but now we no longer pay QST on some.
Why? What do you
Like
mean?
ice cream.
Oh, yeah.
A small ice cream.
A small ice cream, you don't have to pay a QST?
Not anymore.
Why?
Because they removed it.
The government of Quebec removed the sales tax from
Yeah.
small
Well,
ice cream?
Small ice
do you
cream,
mean? So what do you-
pudding,
What?
toilet paper.
Okay, toilet paper is a necessary, like, staple, but why small ice cream and how small?
Okay,
What are we
so
talking about here?
Basically, the law says for ice cream, if it's more than 500 ml,
Okay.
it's
big?
it's
So-
it's a zero tax.
Okay,
because
wait a
It's big enough that
Okay.
you will not eat it outside the groceries, like live.
Then you do or you don't pay tax?
You don't pay tax because it's big enough.
If you pay, so you pay tax on small, but you don't pay tax on big.
Exactly.
Okay, so I had that
Because-
backwards. I thought you were telling me that we didn't have to pay tax on small ice cream, and what you're saying is we do have to pay tax on small ice cream, but we do not have to pay tax on big ice cream.
And now they're changing the law because inflation, and now the big 500 ml ice cream is now 454 ml, and now it's technically taxable.
Are you serious?
Yeah.
So because they did shrinkflation, the grocery store did, everything dropped under the
Under
taxable
the requirement.
amount.
Yeah.
And so they have to get it back in again? Or what?
And now it's zero tax again. So you will not pay QST on
Because
on
of
small
shrinkflation.
ice cream pots because of shrinkflation.
Brought to you by Galen Weston and the... I don't know who runs... I actually don't know who runs Loblaws anymore. But that's
It's
shrink...
his son.
But it's not... It's
Is it
probably not
Galen
them. It's
Weston
not them.
Jr.?
No, because it's whoever makes the ice cream. So brought to you by Ben and Jerry's. Shrinkflation. Taking you right out of the tax net. You're
Well,
welcome, says Ben and
Anyways,
Jerry's.
Loblaw is not groceries. It's a bank.
We are so far off the topic, but like,
Let's go back.
It's startling to me that what you're telling me is because of shrinkflation, we just dropped a whole category out of the consumption tax net.
Yeah.
Oops.
And a bunch of stuff like pudding.
Yeah. Yeah.
I don't remember what else.
So everything that dropped under 500.
But it's some categories like
So this is what you get when you build a consumption tax and then you do this where you set a size cap and then we have shrinkflation
Yeah.
dropping us.
it should be
Honestly. The law of unintended consequences.
exactly.
Yeah. Okay.
Article 16 provides for procedure for taxpayer to lodge a claim, blah, blah, blah. This article does not in any way remove from this court the jurisdiction of determining whether in a case such as the present one, a non-resident is at law entitled to benefit from a specific exemption provided for in the treaty. The defendant relies also on certain statements in the case of Holbrook Davis versus the Queen, where Justice Descaries,
Yeah.
it was French for real,
Absolutely. Oui.
Justice Descaries, but with a Y, not like the highway.
I don't know. Does it have an IE?
Yeah,
Oh.
Descaries highway is like IE at the end.
Really?
Yeah.
Different Descaries,
Descaries,
apparently.
yeah.
Okay.
Justice Descaries, we don't know if he had Descaries.
But he did make
Stumch.
certain assertions. So, yeah, sorry. I don't know what just happened there. Sorry. I missed it. It was a French joke, and I missed it.
Because it's Descaries. It sounds like Descaries, like having cavities.
Yeah, I completely missed that. My French vocabulary does not extend to
That's not
dental
very
terms.
funny. But it was a dental joke.
Yeah, it's like
French dental joke.
But yeah, that's just whoosh.
Are you a fan of French dental jokes? Comment down below if it's the case. And you might win a visit to the dentist. You will not. I assure you, you will not.
I assure you. See, you made an assurance.
Oh,
You see that?
I assure you. I didn't say I insure you.
Yeah, you said you assured.
But do you have dental assurance? Oh, you have dental
You have
insurance.
Yeah, I don't know why it's called the Great West Assurance Assurance. I don't know. I assure you, I don't know.
Do you insure me?
I do not insure, but I do assure. Oh my goodness. We are devolving here. Okay.
Made certain, when it's the last page, this is what happens.
We have, I feel, not had a lot of clarity from this case. But anyway, okay.
Made certain assertions regarding deemed dispositions as they affect non-residents.
Yeah.
The facts of the case, however, indicate clearly that the taxpayer was a Canadian resident and not a non-resident when the deemed dispositions apply.
Okay.
The statement relied upon by the defendant therefore constitute obiter dictum.
Well, okay.
When the case went to the Court of Appeal, the statements were not relied upon in any way, and the appeal was decided on the sole ground that the appellant taxpayer was in fact a resident of Canada at the time the provisions apply against him. For the reasons above, for the above reasons, the claim will be allowed with costs. The assessment will be set aside and the matter referred back to the Minister for reassessment on the basis that the capital gains on the stock in issue were not taxable for the year 1977.
What? Okay. So I'm not sure what this was about non-residents and residents. When we started this case, weren't we told this guy was a U.S. resident?
There is no dispute as to the facts in this case.
Yeah.
An American resident.
American citizen and resident. American is not defined, but I assume they meant U.S. American and not Canadian North American.
Well, they meant a resident of the continent of America.
Well, I don't think
He
that's
was,
what
in
they
fact, a resident of Brazil.
They didn't even specify north or south. It could be from anywhere.
Yeah.
Okay, so I'm not sure why at the end we end up having a discussion about being a Canadian resident. So I just want to check and make sure I understand this. So it says, at the beginning, it says, the deceased, an American citizen and resident, died in the United States, died there in the United States in 1977. And at the time of the death, he owned shares in these Canadian companies. And because, so just to vulgarize this, because the Canadian companies, the shares were in the Canadian companies, why is he deemed to dispose on death if he's not a Canadian resident? Why is he deemed to dispose on death? Because of the section 70, whatever, paragraph 75A. So if we skip down, it says, where in a taxation year, a taxpayer has died, the following rules apply. Mm-hmm. But a taxpayer doesn't mean resident. It could be non-resident taxpayer.
It's a non-resident.
Yeah.
So you would have to be taxable under...
Well, now 2-3.
2-3.
Yeah.
So it would have been taxable Canadian property.
Exactly. So he's a taxpayer either way. He's got taxable Canadian property, or he's a resident in Canada. He's got a capital. So that's how I'm saying, like, I don't think it matters that that's why it's a taxpayer. So he's subject to this deemed disposition. So at the end, though, if we go back down to the very end, there's this discussion talking about the defendant also relied on certain statements where Justice Descaries made assertions regarding deemed dispositions as they affect non-residents. But in this, the facts of the case, meaning the one that Descaries was talking about, that's the one where the taxpayer was a Canadian resident and not a non-resident. And so I guess the court or the taxpayer here is saying, or the court here is saying, fine, but it's not relevant, or it's obiter because we have a non-resident here. I don't know why that matters. I'm not sure why he threw this in at the end.
I don't know. It's just like to address an argument by the Crown.
Okay.
The Crown is like, oh, by the way, this.
Okay.
And the judge is like, doesn't.
Well, it's fine, whatever. But it shouldn't matter. Like, as we just established, it
Yeah.
doesn't matter whether they were
Exactly.
resident or non-resident. Okay, so let's go back up to the money quote. Do you remember where it was? The one that we see from Crown Forest. Because we're going to come back to this and read it in Crown Forest because I think
It's there. It's there.
Where
it's
are you?
there.
Page. Now, these
166.
older cases don't have paragraph numbers, which can be a little bit annoying.
So it's the last paragraph in 166.
Okay, so
Contrary to an ordinary taxing statute, a tax treaty or convention must be given a liberal interpretation with a view to implementing the true intentions of the party.
okay, and the way this is justified in this case is through the Vienna Convention on the Law of Treaties that talks about object and purpose, context and purpose. The article by David Ward,
Yeah.
right? And then some cases that cite or cite approvingly or quote approvingly language to the same effect.
Yeah.
That treaties have to be interpreted liberally. But I'm not sure, like, as far as the text of this case, I'm not sure that we needed any of that. So I'm not sure what exactly has been accomplished here, right? Because here, it's straightforward. You have paragraph 78.5 saying, deemed disposition taxed on the capital gain. And then you have a treaty that says, no tax on capital gain if you're a resident of the other country.
Yeah.
And so what does a large or liberal interpretation with a view to implementing the true intention of the parties, how does it get us there?
Well,
what are the steps? I feel like there's some steps, but
think
it's hard
there's-
to see them.
There's something missing, which I think is the reason why you want a liberal interpretation of a treaty is because it will help the taxpayer. So you want to help the taxpayer as
I
much
see.
as you want.
Okay. So I would say the argument, if I was writing this judgment over again, like if I was just starting over, what I would say is the government's argument here is we did not have capital gains in the act when we signed this treaty to which you are applying for relief. So my strict interpretation of the treaty is if there was no such thing as a capital gain in Canada when I signed the treaty, then you can't be eligible for relief from tax on a capital gain in Canada. That seems to be the
That
government's
seems to be the argument.
argument.
Which I would say, well, you government, you signed a treaty with the U.S. The treaty is reciprocal.
It is
So
reciprocal.
you must have intended the same outcome to apply both to Canada and the U.S.
Right. And so the only way to answer that, I mean, okay, here's what I'm trying to work out. One way to answer the government's position in this is to say, okay, but just strict legal interpretation of the words of the statute in question being this 1956 implementation of this treaty, the words say that non-residents of Canada are eligible for exemption from capital gains in Canada. That's what the words of the treaty. Why would you not apply them to me? And I am thinking to myself that you don't need a large liberal intention of the parties. You could do this on a strict textual, you just have to apply the treaty. And the reason that it's not straightforward is simply this fact that there was no capital gains at the time we made those words. We said those words. When we said you were exempt, we didn't have capital gains. So it's a contextual argument. The government, in other words, the government's argument is contextual. It's saying, hey, at the time we wrote those words that you'd be exempt from Canadian tax, there was no Canadian tax, so you can't be exempt from something that doesn't exist.
Yeah.
That's contextual. And so it's purposive in a sense of like, well, what's the intention of the treaty? Well, it wasn't to relieve Canadian tax because there was no Canadian tax. So therefore, you can't come into court now and say the purpose of the treaty was to relieve my tax.
Yeah, because if you go back to the Vienna Convention, you could say we could not have agreed to exempt you from something that doesn't exist.
Yeah. Yeah.
But if you put it in a reciprocal way, that's because you thought that if ever you had this tax
Exactly.
in the future, I want to relieve you.
Yeah, and so that's why here earlier on somewhere they say like it's you can imagine things that are going to happen in the future. Like you should be presumed to imagine things that can happen. If you sign something that's reciprocal in nature, there's something in the back of your head says, well, if ever we were to tax capital gains, we would extend this reciprocally to the U.S. Like, actually, it's interesting, right? Because the idea is, like, Americans, you're negotiating with Canada for a treaty, and you're saying that you, America, will not tax Canadians that have capital gains in the United States in exchange for us, Canada, not taxing you. Well, we don't tax you, so you should just go away, and you don't need this provision, right? You should just give us the relief. It should be one-way relief. And you could imagine the U.S. negotiators saying, you could imagine them in the room saying, well, yeah, okay, fine, you don't tax capital gains now, but I don't want you to ever tax capital gains. I don't want you to be in the position of adopting a capital gains tax later, and then I'm relieving and you're not. So obviously I want it to be reciprocal.
Of course.
Right?
Of course.
Well, that's why it's reciprocal and not one way. That's why. That's why anybody would have a treaty that has something that's reciprocal when they don't have a domestic law of that nature.
Well, except if they're like, if ever we implement this, we don't want to relieve you.
Okay, exactly. Protective the other way.
Yeah, you could protect it.
Right.
But if
So, yeah. I mean, I conclude at the end of this case that, as we've already noted while we were reading it, that there's a lot of extraneous yapping about general principles.
And the case is basically, here was the facts, quote, 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 quote,
Yeah.
and
And therefore, the end. Yeah.
yeah.
Yeah. So, but it's fascinating then to me that when we get to Crown Forest, which we'll read next, we're going to have that money quote. We're going to use that money quote, and we're going to say, like, this is the true intention. But they just threw that in there and didn't explain why we needed true intention at all. Like, they didn't discuss true intention. They didn't talk about intention.
They were not even explaining the true
Not at
intentions
all.
of the parties.
Not at all.
They were not
No
explaining
discussion.
why it's there, why
No.
it's reciprocal.
Nothing. We're posing that now.
Yeah.
We're suggesting, well, maybe it's reciprocal because the U.S. doesn't want to give up, because U.S. doesn't want to give up unless it's assured that America,
like-
that Canada is going to give up.
You're telling me the goal of the interpretation is finding the true intentions
Yeah.
of the parties.
Right. Well,
Yet
what are
you
they?
are not finding the true
Right.
intentions of the party. You don't even
Exactly.
discuss
Not
the
even
true
discussed.
intentions.
Yeah. So I think we'll see when we go to Crown Forest, maybe some more discussion about what these intentions are, true or not true, or false or fake news intentions. And but what we see right away here is something that is frustrating to readers of the law, which is the court will say, will make a claim, and then that will become judge-made common law doctrine, but there's nothing behind it. There's no analysis to help us.
Because they will be like, oh, in Gladden they said that. No
Yeah.
one reads Gladden.
Right,
And now it's like, oh, the Supreme Court said
right.
that.
But we still
But
don't
it's
know what
based
it
on
means.
nothing.
It's based on nothing. Yeah.
And the word true intentions. Intentions
Never.
I can agree, but
Yeah.
the true intention,
Never even
it's not in the
raised.
Vienna Convention, it's not in the word
not there.
article, it's
not there.
just a word that the judge added in
Yeah.
the sentence
Yeah.
that means nothing.
Yeah. So we, as usual, don't like that kind of law because it doesn't give us analysis. It just gives us claims, which then are later going to be used one way or the other in a way that can't be justified. And now we have no explanation for them. So yeah, great.
Well, thank you for watching. Thank you for being here with us. This was the Tax Files.
This was the Tax Files. See you next time. Nice. Very good.
And now you can see this beautiful studio.
Here we are in the studio. Saying goodbye. Till next time.
Goodbye.
Bye. So hit this guy first. Turn off the screen. Nice. We're going out on. No, not that one. The other.